All right, well, I'll open us up with some just some housekeeping and an introduction that'll allow some last minute attendees to join us and not miss any of the actual presentation. So good morning. My name is Katie Malinowski, and I'm the Executive Director for the New York State Tug Hill Commission. We are pleased to host today's webinar on small wireless facilities and 5G in New York State. Thank you very much to Rebecca and the New York State Conference of Mayors and Municipal Officials for graciously agreeing to present this webinar. A few housekeeping items. We have muted everyone except for our presenter to cut down on background noise. Please type your questions in the Q&A section at the bottom of the screen, and we will address them at the end of the presentation. Many of today's participants are from outside of the Tug Hill region. Welcome. We are glad you are here, as the topic is certainly relevant for local officials throughout the state. The Tug Hill Commission is a small state agency that serves the Tug Hill region, which is a 2,100 square mile area in portions of Jefferson, Lewis, Oneida, and Oswego counties, and includes 41 towns and 18 villages. We provide technical assistance to Tug Hill local governments, not-for-profits, and other organizations in the program areas of land use planning, community and economic development, and natural resource management. We organize an annual local government conference of over 650 attendees at Jefferson Community College in Watertown every March. Today's presentation was originally scheduled for that conference, but was canceled because of COVID-19. A recording of this webinar and others on our original conference schedule are available on our website. Rebecca will share a URL in her presentation.
Didn't mean to do that.
Or we'll put it in the Q&A. That's okay. Today's presenter is Rebecca Versito. Rebecca serves as counsel to the New York State Conference of Mayors and Municipal Officials, where she provides legal assistance and training to city and village officials on a variety of municipal issues, particularly those relating to telecommunications, energy, the environment, procurement, village elections, and water and sewer system administration. Prior to joining NYCOM in 2016, Rebecca served in state government. She is a graduate of Brown University and the Maurice A. Dean School of Law at Hofstra University. So I will now turn it over to Rebecca.
Great. Thank you, Katie. Are we going to do those polls now? Okay, so good morning again. I am Rebecca Versito. As Katie said, I am one of the attorneys for the Conference of Mayors. Many of you may know me if you are a village local official, for instance. So perhaps you see a friendly face. I cannot see any of you, so I don't see any friendly faces. I just see the little dot of my camera right now. But this morning we are going to be talking about a whole bunch of different things related to 5G and the technology and the regulations. And so I have a couple polls here that are just going to inform me as to like where you are situated right now. So it looks like many of you, most of you, are planning board and zoning board members, but we do have other officials here, some attorneys, and a couple technology officers. Okay, I'm gonna end the polling so we can go on to the next question. Oh, look, we can just share the results. That's so cool. I've never done a polling with part of this before, but so you can see where everyone is sort of situated in terms of your role. Well, you know your role, but now you know what your fellow attendees also do for the local government. Okay, can we do our next question? My next question is how familiar you are with 5G. Great. If you could give this webinar, I'm not sure why you're an attendee. I mean, great for Tug Hill Commission, but I don't know what you're doing here. So let's see, let's share those results. So it seems the vast majority of us here today are maybe not very familiar with either the technology or the regulations affecting them. So very good. And I think we might have one more question. And then this one is about, have you received an application? Okay. So it looks like most of you have not or not sure, or maybe you've received a few. That's great. That's good to know. So there is a raise your hand feature. I'm not very familiar with how that that works on Zoom. I've not used that feature before. And while I encourage you to put your questions in the question and answer section, I'm probably not going to be addressing questions as I go along, but Katie and the Tug Hill staff have a chat with me. So if there is a common question that seems to be being asked often, or if I'm not being clear about something, they can alert me to that particular issue. But there should be plenty of time at the end for questions. So okay, with the understanding of where you are, or where who you are, and the working the information that you're working with, I think we'll have a great robust conversation later, and hopefully this presentation is very informative for you all. So this presentation, I've given versions of this presentation many times now. As a statewide organization, NICOM as a statewide organization, we do have a pulse on municipalities throughout the state that are managing this type of issue, right? So I like to think that we're pretty well equipped to have a variety, to represent a variety of perspectives on this issue, whether you are full in, very supportive of 5G and this technology coming to your area, or if you're perhaps a little bit more skeptical about it, and the authorities that you may not have any longer relative to citing this type of infrastructure. So some of you might be saying, wait, I don't even know what the infrastructure is yet. I will get to it, and we will talk about that. Also, we're going to start by talking a little bit about the health effects. I don't really get into this because this is local governments can't regulate on the basis of health effects, but we can touch on that. And I know that if you have received citing applications, and a fair number of you have, this is going to be an issue for your constituents. It seems to come up invariably. So we'll talk about a little bit of 5G and COVID-19 and the perceived health effects. We'll talk about the wireless technology itself. We'll talk about 5G, what that means, and the infrastructure that is used to propagate that cellular network. We'll spend most of our time talking about the regulatory framework impacting the siting decisions we can make as local governments relative to this equipment. I'll give you a little overview of what's going on the state and federal level relative to this same topic. And then I do have some best practice recommendations and some samples. So all of the information that I will be speaking about today, including my presentation, is linked at that short link, the second link, the bit.ly link, Tug Hill 5G. And also, as Katie mentioned, the top link is the link to all of the presentations. I just created another short link to give you access to that. And again, if you go to the Tug Hill 5G link, this presentation is available there. It also, if you're not familiar with this concept, if you're not very familiar with this, there's going to be maybe an overwhelming amount of information and that link. I have included all of my sample policies. I've included articles that I find to be relevant. I've included the actual third report and order regulations that were issued by the FCC back in 2018, the publication in the Federal Register. A lot of information is there. The articles that I've written for NICOM relative to this. And so if you need any help like sorting through it, by all means, just let me know. Also, please be advised that the sample policies I have linked there were not created by me, were not created by the NICOM staff. So if you are going to use any of that language contained in those documents, you need to be certain to review it thoroughly with your municipal attorney. So just with that warning there. So that's what we have. So Katie mentioned that I was in state service prior to NICOM, and I actually was counsel and legislative director for Senator Patty Ritchie, which I think is maybe half of your state senator. So I'd like to think that that experience gave me a good foundation for understanding issues that are important to individuals who come from rural places. And so certainly this presentation is going to be focusing on 5G and that technology, or the small wireless facilities that are used to promote or help 4G networks. But I'm very sensitive to the fact that this technology may not be coming to your community right now, or may not be there very soon. It's sort of that last mile question a little bit. It seems to me, and from the feedback that I've received from my members, is that this technology, the 5G technology, is really being deployed in areas where there's already substantial cellular networks. So if you're in an area that doesn't have that, I'm not confident that you're going to be seeing this, but I do think you can take steps to make your community ready for when 5G or 4G densification is coming to your community, and therefore make yourselves a more attractive location to foster the deployment or investment of this technology. So I went on to my first slide here, and it's 5G and the coronavirus. All of us are dealing with the effects of this international pandemic, and I want everyone to be very, very well aware that there's no connection between 5G and the coronavirus. In the UK, there were 77 arsons as of last week, I believe, attacking the cell towers. And you can see this is a picture of one that I found on an article in the New York Times. So clearly, there's a lot of misinformation out there associated with 5G and the coronavirus. So this is a picture of a demonstration, obviously before Corona, when we could actually be out and with each other. But the 5G in general, cellular technologies, I think for a long time, but 5G in particular, because of the way it's transmitted and the newness of it, has created a lot of attention both for and against this type of technology and communication network. So here's a picture of protesters. So again, the conspiracy, it is a conspiracy. There's no basis in science or technology that there's any link between 5G and this virus. It's on all social media sites, so your Twitter, your Instagram, your Facebook, it is there. But there's no basis, and there haven't been any attacks in the United States that I found, or at least any arsons or attacks on wireless facilities that have been attributed to this conspiracy that I found. So we're good. It seems like most of us are aware of the situation. But to speak about the health effects for a moment, the Telecommunications Act, when we'll speak about this again a little bit when we talk about how we can regulate these facilities, but the Telecommunications Act really prevents states and local governments from regulating on the basis of perceived health effects. So the TCA sets forth that we can't regulate on this topic, and that the Federal Communications Commission, the FCC, regulates radio frequency emissions. So they are the agency that supervises this. And as states and as local governments, we don't have the authority to make a regulation or to refuse an attachment or a cell tower on the basis of these perceived health effects. But again, that doesn't necessarily help us when we are dealing with a constituency that is maybe, again, you know, there may be a vocal minority or majority that are against it. So I'm not quite sure about the audience here and which end of this sort of spectrum of 5G your constituents are sort of falling, if it's something that they're much more excited about and to foster that connection, or if it's a little bit more on the end of wariness. But I think it's important to work with your applicant in order to educate the public on these perceived health effects. So it's not just, we can't do anything about it, but here's a tool, here's the education, here's the background on this, on the science here, like supporting this. So I mentioned that 5G, it operates differently than, or if I haven't, 5G operates a different radio waves than previous versions of cellular service. 5G is the 5th generation of this technology, so 4G being the 4th and going backwards. Millimeter waves are different. They're different than previous generations of the technology, which make them better and worse at the same time, and we'll get to that in a couple slides. But just to again talk about those health effects, that no national or international health agency has concluded that there have been any causal relationship between cellular networks and health effects. I think this is something that is going to be continued to be studied. There are going to be a lot more 5G nodes necessary to really have a full service of this technology. So I think this is something that we're going to be hearing more and more about. But Cornell's radio frequency safety program indicates that it penetrates skin less than frequencies. I read an article that said it can't penetrate skin. 5G can't penetrate walls and is very susceptible to environmental factors. So that's why it's got its ups and downs in terms of its effectiveness, I think. So, or that's my opinion is what I'm saying. So certainly the conclusion though here, the radio frequency emissions for 5G antennas is below ultraviolet visible light. So let's talk about the technology. I've been throwing around words like 5G and nodes and antennas and small wireless facilities, and some of you may not be as familiar with that. Some of you looked like maybe about half of you are pretty familiar. So you understand that we are living in a world where the Internet of Things has taken over. We have so many more devices for everyone than we have people on the planet. This year we will reach about 31 billion Internet of Things devices. Those are our cell phones, our laptops, our tablets. If you have a smart thermometer or a smart, I guess thermometer, when you control the heat in your house, that would be part of the Internet of Things. If you remember, if you have a refrigerator that you can see the inside of it from your phone when you're at the grocery store, that's all part of the Internet of Things. So certainly all of these devices working on these networks, we need internet that can sustain that. I mean, for me, I have my computer that I'm speaking to you on. I have my work computer here, my laptop, my tablet, and my cell phone just in this one room in our house. So certainly there are so many more devices than there are people, but it's not just our personal devices and making the internet faster and better for our own uses, but it is also the expanded universe of 5G. So again, 5G is the next generation wireless technology. While there's no official definition, we know certain things about it. I've mentioned that 5G operates on millimeter wave. That is the technology that is primarily being used by Verizon and AT&T as internet carriers. T-Mobile and Sprint are using a different technology. To me, and I'm sure that there are maybe those others that could give this presentation instead of me would have a differing of an opinion, but to me, true 5G is a 5G network that operates on millimeter wave. But in order to have a complete system of that, it's going to be a very long time. And so T-Mobile and Sprint are using, it's just like boosted 4G service, if you will. So when we think about the technology and we think about getting it to people, it's not just 5G we need to be talking about, but it is the 4G network as well. We're talking about network densification, and all of the regulations that we'll talk about later are going to be affecting both types of applications or both types of systems. So I mentioned how it's not just us. It's not just like your personal use of your devices, but it's also access to telehealth. And I think this is one of the biggest ones right now. Certainly telehealth is really important during this crisis, right? To really have ways of doing remote diagnosis and treatment if possible, in general. So that is certainly going to be more available with 5G technologies. I believe I just remember this, so I didn't look at this in preparation for this presentation, but I believe there's already been remote surgery. So using the 5G technology, that a surgeon would actually not be operating on the patient directly, but it would connect, and then the procedure would be done like robotically by a machine, but me, the surgeon, would be controlling the device, if you will. So certainly telehealth expansions are important. I also think of autonomous vehicles. We'll talk about the characteristics of 5G. I'm just going to move forward to this slide and then we'll go back. So what we know about 5G is it's much faster. So we can download things much more quickly. That's basically what it is. It has lower latency, which means more responsive. So that's when I think of our autonomous vehicles, right? So that will only really be possible with a true 5G network, because we need to have those vehicles communicating with each other in better than real time, if you will, in order to avoid collisions and things like that. And superior connectivity, so it connects more devices at once. So going back to this slide, that's how we think about all of these different types of operations coexisting. If we're using all of these at once, we're going to be using a lot of the internet, and how do we make sure that technology and connection is going to be robust and not impacted by either environmental factors or other things to have adverse effects for these. So certainly you can imagine autonomous vehicle, if you drop the signal, that would be really bad, right? Because then the car wouldn't be able to operate itself. The same thing if we think about drone monitoring. I was also thinking about this in terms of the pandemic and how great it would be if we had drones delivering packages. We're not that technology, we're not quite there yet, but that is something that 5G hopes to bring about. And certainly more smart home and smart city management are excellent. So again, we know about 5G. It's faster, it's more responsive, and it can connect more devices at once. I mentioned that it operates on that millimeter wave, but there are certain detriments to this, right? It can only travel over shorter distances. It's impacted by the environment and weather. So sometimes I think of, satellite service, how that may or may not be considered a broadband service, but it is very impacted by the weather. And so in order to propagate this service, in order to really have a 5G network, we're going to need lots and lots of small wireless facilities in order to support all that connection. So what are these? These are sometimes called small cells. You'll hear them referred to as nodes or as antennas. They are, you might even remember seeing them when you're driving. Now that I'm really focused on this area, I see them everywhere because now I'm looking for them. It's kind of like when you get a new car and then you only see that car on the road. I think it's something like that. So certainly these are, you can almost think of them as like your Wi-Fi system in your house and how you might need, well, you may have your connection come into your home or your apartment, but the design of your living space may make it so that the signal can't be transmitted that easily. So you need to have like a little booster device elsewhere in your house in order to support the service. Small cells or small wireless facilities are basically versions of those boosters. Certainly for a 4G network. So 4G towers send out that signal to sort of a triangular defined area. And within that area, there are buildings, there are people, there are trees, there's all of these things. And that can impact the transmission of the signal, right? So by having a small wireless facility within that triangular space, you're able to boost that service. So you're able to densify the network within the space. So both nodes for 4G and 5G will continue to be necessary. 4G is not going away. We hear all about 5G and how great it is and how it's coming soon. But 5G nodes will not replace, 5G nodes will not replace our 4G antennas, okay? So this is to increase service to a dense area, whatever that density may be, if it's trees or if it's buildings, but it's within that defined area. It does not fill in gaps in underserved areas, right? So I mentioned that at the beginning, that it's been our experience that the most applications my members are seeing are really in places that already have robust networks. This is not really, 5G is not really going to serve areas and locations that don't already have wireless service. So we'll have to see what happens. Prior to the pandemic and us moving to a work from home situation, I was pretty confident that there had not been any 5G deployments in New York State as of yet. I know that the city of Syracuse is very close. I don't know if they've had any during this time, but there had, despite us all talking about 5G, and despite maybe your phone showing 5G service in the different parts of the state, we really don't have real 5G connection here just yet. Like I said, Syracuse seems to be well on its way to being the first city in New York State to have that connection. And I think Rochester may be following, but there are some other issues we'll talk about with Rochester and their telecommunications policy a little bit later. That was your teaser trailer. So I'm not sure about this technology filling or meeting an unmet need but I do believe we're going to see more and more 4G densification, and that technology is not going anywhere for a very long time. So where do these small wireless facilities go? Well, I think it's probably intuitive to you all now that these are going where the people are, right? So they need to be where we use our devices. So they are going on streetlights, utility poles, on buildings. They need to connect back to a network, but so you'll think about also those, we call them like refrigerator-like structures, right? So they're like big silver cabinets that you'll see on streets, and that has a lot of the backhaul equipment and all of the associated facilities to assist the network. So both indoors and outside, these will need these technologies. Certainly for 5G, we'll need them in both locations, because can't really penetrate walls is what I understand. So if you have a service that is being transmitted in a way that is susceptible to these environmental factors, we understand that we're just going to need more and more of these antennas. And keep in mind, not only will we need more and more of these antennas for 4G, they're not operating at the same frequency, so you'll need 4G and 5G nodes as well. Also, keep in mind that towers are not going to be going anywhere. We are still going to need towers. You may still have received recent applications for towers. I actually have been getting a few questions from our members recently related to the leasing of these structures. So certainly that's really what is transmitting the service, and then the small wireless facilities are proliferating that network within the defined area. Okay, so I am going to try to take a look at some of these questions that have been coming in, because we are going to transition to our regulatory framework. But let's see. There's one question: when will dependable cell service come to the Adirondack State Park? I think that's a very good question. I think that there's not, I don't have an answer. I think things like FirstNet, which is the ambulance or 911 service that is being supported by AT&T, they received a federal contract to have this network just for first responders. So certainly, I think that will help, because certainly there are communities within the Adirondack State Park that that will need that service. So I'm hopeful that FirstNet will assist with that. Let's see. So the question is, how does a municipality get an application for a wireless facility? So the applicant would be from, the application would be from one of the providers, or perhaps an organization or a company that would assist a third party. What's the word I'm trying to look for? So for instance, we have our 4 major providers, right? We have AT&T, Verizon, T-Mobile, and Sprint. Those are really our only national carriers that we have. But there are other companies that help those providers. Those are the 4 that are licensed by the FCC to provide service. So then we have these other companies that help support the service. So you might have heard of the company Mobility or Crown Castle or Extenet, and those create the types of technologies, or they create the antennas that the actual service will be transmitted through. So Verizon creates the network, but Crown Castle, for instance, might be generating the nodes that will be used to propagate that service, or to complete that service. Okay. Let's see. I don't know if 5G, there's a question, does 5G interfere with GPS signal? I am not familiar with any types of relationship. I doubt it because of the frequencies over which it operates. So I don't believe that GPS operates on millimeter wave. So there's some questions about antennas and how to find out where they are. I believe there are some websites out there that sort of track this, but I don't know if they are very comprehensive in their information in terms of where they're being deployed and where there are some 5G maps, but I think you'll see that there aren't many in New York State. Okay. All right. I am going to get back to the presentation, and we're going to talk about the regulations now, and then we can go back and discuss a lot of these questions at the end. So let's take a look. When we're talking about the regulatory framework that we operate under for the deployment of these types of facilities, we are really talking about the Federal Telecommunications Act of 1996. It sort of provides 5 parameters under which states and local governments can act when siting cell towers and small wireless facilities. So the Telecommunications Act provides that groundwork, and then the Federal Communications Commission, the FCC, has interpreted this statute, and that is what has provided our more detailed regulations. So certainly for our 5G deployment and for our siting applications for small wireless facilities, we're going to be looking at the third report and order. And then there are previous iterations of that affect cell towers. And I'm going to talk about both cell towers and small cells in this part of the presentation, but I'm going to try to identify when we're only speaking about small wireless facilities. So the TCA to me raises 5 important questions. It prohibits unreasonable discrimination among equivalent providers. So what does that mean? What is unreasonable discrimination? It bars local policies that have the effect of prohibiting personal wireless service. So what prohibits personal wireless service? Requires local governments to act within a reasonable period of time. What does that mean? What is reasonable? Permits fair and reasonable compensation for telecom providers' use of the right-of-way. What is that? What is fair and reasonable compensation? And it preserves local zoning authority. How is local zoning authority preserved? So I mentioned that we have this third report and order. It was published in the Federal Register back in late 2018 and became effective in January of last year, and did contain a provision that talked about aesthetic considerations that must be adopted by what was April 15th of last year. So I don't think that is cause for panic or that is cause to not adopt a telecommunications policy addressing aesthetic considerations. Provided that you haven't received any applications, I think now is the time to prepare for an application. So we'll talk about how to develop these policies and what can be considered in them. But don't be scared or don't be put off by the date, April 15th. I think you'll be fine. So this is the third report and order. If you hear like a 5G order, this is really what is being discussed. So what is a small wireless facility under this rulemaking, under these regulations? They are antennas that are less than 3 cubic feet with the associated equipment that is less than 28 cubic feet, which is about the size of a refrigerator. That's sort of why we use that term. And they cannot be on a structure that is taller than 50 feet. Okay, so to the first question, what is unreasonable discrimination? So you'll hear this a lot. We need to ensure that we are treating all of our applicants in the same way, that we are not engaging with AT&T, for instance, in a more favorable manner than we are engaging with T-Mobile, okay? So we need to apply the same set of fees, we need to apply the same set of application procedures. This is the same. There's no difference between the regulations that affected cell towers or the regulations that are now affecting small wireless facilities, okay? But there are some differences moving forward. So what has the effect of prohibiting wireless service? We had always thought of this as if there was a significant gap in service and there was not a less intrusive way to provide this service, the provider must be allowed to install their facility and in order to provide wireless, or excuse me, cellular service to that area. Similarly, those modifications to those facilities, towers, couldn't substantially change the physical dimensions, and there have been other FCC orders that have very much articulated or specifically articulated those parameters for the physical dimensions in which you can be greater than what was originally approved. So what the third report and order does, it expands on that. And it establishes for a local government when reviewing an application for a small wireless facility, it applies this material inhibition standard. So it basically says, if you are limiting the ability of cellular providers to compete in the area, you are materially inhibiting them from participating. And because of that, what this really means is, excuse me, not municipalities, providers can't be prohibited from densifying their networks. So this is, and this rationale comes from a FCC decision back when we used to have payphones called the California payphone decision. And in that instance, what the FCC said, even though there may be lots of payphones, if more are needed because this is an important service that we're providing to people, the person may put, or the company may put in more payphones. So we're not talking about really payphones right now. We're talking about cellular connectivity, but it's the same concept of you can't inhibit network densification. There can never be too much service is basically what that means. Even if you have, let's say 3G service, if we can make it better with 4G, you as a local siting authority can't prevent the applicant from participating, from having that network densified, right? And you can't prevent AT&T from being a participant in this market because you already have Verizon, for instance. So everyone needs to have, a bite at the apple type of thing. They all need to be able to develop their networks, and they need to be able to, all of the industries or telecommunications providers need to be able to support their networks as much as they can. Okay, this regulation, this material inhibition standard, also applies to third parties when those third parties are going to be used to transmit the service. So when you have mobility putting up 4G nodes, provided that Verizon is using that node to transmit service, then this standard will apply to those types of applications as well. Obviously, I'm using the names to give you a point of reference, but it's interchangeable. I'm making them up as I go along as to which company I'm referring to, so just be aware of that. Okay, so what is a reasonable period of time? So in 2009, we had what was called the shot clock, the first shot clock guidance. Many of you may be familiar with this, where we had 150 days to review a brand new cell tower application and 90 days to review any modifications or co-locations to that application, right? That was our original shot clock. failure to act on that type of application would result in the applicant being able to appeal to the court and say, court, municipality did not review my application. Please grant me default approval to put my cell tower in this location. And the court could then, on the basis of the shot clock, grant that request. So similarly, we have a shot clock for small wireless facilities. It's 60 and 90 days. So 60 days for co-locations and 90 days for new constructions. This must include all elements of your permitting process for reviewing these siting applications, okay? These are your road closure permits or your building permits, whatever the case may be. All steps of that approval must be included within that shot clock. There are no deemed granted provisions, so much like the previous shot clock, it's not an if you fail to act within the shot clock, the applicant will not be able to automatically put their antenna where they're requesting. They'll have that same level of authority to appeal to the court to say the municipality didn't act. I made this application, it was complete. Please grant me the authority to install my small wireless facility. And the court under these regulations could say, yes, you're correct. You're allowed to do that. So what is a co-location? A co-location is really any installation of an antenna on a structure that already exists. Okay, so it's not that the structure has to be or should have hosted a cellular network before. It certainly can be a building, it can be an existing utility pole, an existing light pole. Any of those applications to place an antenna on one of those existing structures would be considered a co-location for which the 60-day shot clock will apply. Again, all aspects of the application must be reviewed within that period of time. So don't forget those other permits that you might have associated with reviewing that application when complying with the shot clock. The clock begins upon the submission of the application. So as soon as the municipality receives the application, so if it was received today, that shot clock begins running immediately. Whether or not you can stop the clock will depend on the completeness of the application and the municipality's ability to notify in writing to the applicant that the application was incomplete and in which ways, okay? So it's very important that municipalities act quickly when they receive an application, that they review it and get started because the clock doesn't start. And there's no authority under these regulations to completely suspend the review of these types of applications, right? So sometimes you'll hear, let's put a moratorium on siting applications. There's no authority under this regulation to have any type of moratorium on review of these applications. I'm going to talk a little bit later about now, given our circumstances with COVID-19, if there's an opportunity to stop the clock, but I'll talk about that in a little bit. So ordinarily, you can stop the clock for an incomplete application, and you can mutually agree with your applicant to extend the clock. So I think my experiences have been that most of my members, up until maybe a year or two ago, which is sort of when these regulations were first being enacted, that industry actors were not very easy to work with, right? They were very much trying to strong arm the municipality into participating. That was my perspective based on what my members were telling me. But now it does seem that the industry has changed its approach and is much more willing to work with a municipality, provided that the municipality is showing that it wants to work with the applicant in order to have this technology. And I should back up and mention, this technology is fantastic. This is all cellular connectivity is very important for economic development reasons, for the safety and well-being of our residents. So it's not ever that we want to restrict this service from being brought to throughout the state. It's that we want to make sure that it is being brought to the state in a very different parts of the state in a very thought out, meaningful way that isn't going to leave populations out of participating in this awesome network. So shot clock, can it be stopped? It can be stopped for an incomplete application, and you can agree with your applicant to extend the clock. There must be, as I mentioned, a written notice that there's been an incomplete application that must be given back to the applicant within 10 days. So it's not just that you have 60 days to review this application, you have 10 days to determine whether there is an issue with the application itself. Written notice of a materially incomplete application will restart the clock. So if there's like nothing in the application and you can't work with it, and you can articulate all the reasons why, that would be a materially incomplete application. But notice will pause the clock if there needs to be additional information provided to the municipality in order to review the application. Okay, so what is fair and reasonable compensation? This has been under our previous orders or previous regulations, fees associated with maintaining the right-of-way, provided that they are applied in a competitively neutral and non-discriminatory manner. Again, we need to be making sure that we're treating all of our applicants in the same way. We're not charging different fees for the same type of application or for the same type of applicant, right? So everything needs to be consistent. Under the small cell order, there's been a little bit more of a definition of what is fair and reasonable compensation, or I should say a much stronger definition of what is fair and reasonable compensation. So it must be related to the actual costs incurred by the municipality, relevant or relating back to the installation. So if you have right-of-way maintenance costs, you can only charge what you are incurring. I like to think of it a little bit like when we think about permit applications for parades or any other type of sort of like free speech kind of activities. We can only charge the registration or the permit fee is really only ministerial, right? We can't charge an excess fee for that. So like that, we can only charge what we are actually expending when either reviewing an application or if we're charging a right-of-way maintenance fee, for instance, what we're actually spending to maintain the right-of-way relative to that installation. The order does give us some presumptively reasonable fees, which I think a lot of municipalities are utilizing. And then there are some ways that we can show when we want to rebut the presumption or have a fee that's in excess of that presumptively reasonable fee. There are opportunities to do that. Incentive agreements are prohibited under the order, so you cannot say, well, we'll give you preferential treatment if you give us service at our library. That would be an incentive agreement that would be prohibited under this regulation. So the presumptively reasonable fees associated with applications are $500 per application for the first 5 and $100 per application after that. So it kind of ends up being around $100 for an application fee, and then a $270 presumptively reasonable fee for all of the reoccurring fees. So if you are going to charge any type of right-of-way access fee, or if you are going to be charging any fee for rental on municipal property, like a street pole, for instance, then this will, you will be capped at $270 as the presumption. There are ways to like I said, exceed that presumption, but you really need to have articulated why. Again, the fees that you do charge need to be reasonable. They need to be discriminatory, meaning they need to apply to everyone in the same way, and they need to be based on what you're actually expending. The FCC has said that exorbitant consultant fees are not presumptively reasonable, so you can use a consultant, but the municipality may be incurring more of an expense because you can't just put that cost back on the applicant. I do believe that there's authority to charge insurance, may require that the applicant have different levels of insurance depending on what the installation is. If there needs to be any type of hearing, I think those are reasonable costs to put on to the applicant, but not our exorbitant. That's the terminology that the FCC has used, not our big consultant fees. So looking now to how is local authority preserved, the statute and regulations have always upheld that siting decisions in the right of way are for local governments to determine, right? It is your prerogative to enforce your public safety and aesthetic considerations, and to impose your application's access and rental fees. But the FCC has sort of limited that again in this instance with our small wireless facilities, because they have said you need to publish your safety and aesthetic regulations in advance, which makes sense, of course. An applicant needs to know when they're making that application, how they're going to be in compliance with a local regulation. So certainly being published in advance. Those regulations, those aesthetic and safety considerations must be reasonable. That's a big one. What does reasonable mean? I don't think we've really had enough time to determine what that means yet, but we'll talk about what we think is reasonable. And non-discriminatory, again, applying that same standard to all of your applicants. So localities may enforce those aesthetic considerations when they are not unreasonable. What does that mean? Some camouflaging or stealthing requirements may be reasonable. So this is when we have maybe a smart pole and the antenna is embedded within that pole. Can you require that your applicant use those types of camouflaging or stealthing technologies? And it seems to me, anecdotally, that applicants are okay with complying with those types of requirements if there's a reason for it. So if you have a historic district, for instance, that you have very decorative light poles, and seeing external antennas on them or on other structures in that historic district would not match the aesthetics that are there or that have been defined, then perhaps a camouflaging or a stealthing requirement there would be reasonable. Likely requiring that all of your installations be camouflaged or only be using smart poles is likely going to be unreasonable. We have to think about how do we treat similarly situated entities, right? So how do we treat cable companies, for instance? Do we always make them camouflage, or if we don't, how is this different than what they're installing? So there's just a lot of things that we have to consider when we're thinking about our aesthetic considerations and trying to treat not only the providers or the industry, the cellular industry actors in the same way, but also those similarly situated actors, right? The FCC did say that undergrounding and minimum space requirements could be reasonable. Certainly this technology is transmitted through radio waves. So we can't have everything underground, right? So that's not going to work. But can certain things be underground? Can the cable fiber be underground? Certainly. So okay, that to require that, maybe that's reasonable. The minimum space requirements, I think that this one is a little bit of the most tenuous, because what does that really mean? To have a minimum space requirement if we know that millimeter wave technology and 5G need to be so much closer together to communicate their network. I don't really know how that one's going to play out, or if anyone has really tried to impose minimum space requirements. But those are the three major ways that the FCC said these are what you can enforce here. So again, I kind of alluded to this, that we want to make sure that our regulations are not more burdensome than those applies to other types of infrastructure deployment. So not only antennas for cellular service, but are there other antennas we regulate in a way, or is there other structures like signs or things that we regulate to preserve our aesthetics? We want to keep all of these things in mind when creating our telecommunications policy. Okay, so if we allow lots of pole attachments, for instance, lots of signs can go up, or certain things, lots of whatever, you're probably not going to be able to make a justifiable argument that regulating the telecommunications industries in this way makes sense. Because if we allow those things to already exist on a pole, how do we then say, well, because this is a new application, or because this is a telecommunications antenna, we're going to regulate it? That's not really going to work. So we need to be mindful of all of the levels here. Again, we want to mention that we cannot regulate on the basis of environmental effects. Telecommunications is specific about that, and it's related to health. That's to perceived health effects as well. Okay, so I am going to look to see if there are some questions that I can address for the regulation component, because then now we're going to be moving on a little bit to the landscape, the legal landscape in the state and federal governments. Okay. So apparently I may have frustrated some people with my understanding of the health effects. The health effects are based on the research I've done, but certainly everyone needs to make up their own determination on the perceived health effects. So by all means, do what you need to do with that. Let's see. On third-party rights, must they demonstrate the intent of the actual provider to utilize the facility, or are they allowed to speculate by building out a system and hope to attract a provider? Or can the village require that they have a tenant on their facility? I think that's a great question. So the way the order is written is that provided that that third party is going to host an actual provider, they need to be entitled to the same regulations as the FCC order. If they're not, if that applicant is not demonstrate, if they're just basically occupying the real estate to be ready for when Verizon and AT&T come to your location, I don't believe that they would be entitled to the same requirements as the order requires for providers themselves. Okay, so this is it's while they're not entitled to that, I think it's a little tricky, because we want to make sure that we are still going to be treating everyone the same and all of the type of actors in the same way. So if they're intending, it's a little tricky, but if they are not actually hosting, if that antenna is not going to right now support wireless service, I do not believe that they are entitled to the same regulatory landscape that I've just laid out in terms of the shot clock and the fees presumption and those types of things. Who determines whether or not a modification or addition of a cellular tower is required for service improvement? The service provider themselves. If the question is really well, we want to have more service in this area, then that would be a conversation you would want to have with your provider. And then there's a follow-up, and are there any circumstances under which a landowner can refuse placement of a tower or other wireless facility? So that's a great question as well. Let me back up and say what these regulations are imposing are on the siting authority, right? They're on the municipal siting authority, the local government. Whether or not I have this parcel of land that is available, I as a private citizen may or may not grant access to Verizon to install their tower there. That's not, these regulations are not imposed on me as a private citizen, but on the siting authority. So a landowner can refuse, but the local government may not be able to, for the reasons we talked about, right? Or there might be other circumstances at play that would require them to basically approve the application. Does the new time clock limits, do the new time clock limits apply to completely new cell tower type siting, or do we go by the previous time clock? That's a great question. They're all great questions. The shot clock for a tower will still apply. So the 90 and 150 days, I don't remember that one as well off the top of my head, will still apply for a tower. That has not been changed. Only those facilities that meet the definition of a small wireless facility. So you might remember that slide I had with the moving box and the refrigerator and the tractor trailer truck. The new regulations and the new shot clocks only apply to those facilities that meet that definition. Okay. Let's see, there's a question about the date for aesthetic matters. It was my understanding that the fees also had to be adopted, and it would be more difficult to define fees after the cutoff date. We adopted a safe harbor fee schedule by that date or before sometime this year, but we did not draft and adopt regulations and zoning chapters for 5G. Does the FCC treat the matter of fees more harshly versus late regulations being adopted by a town? So that's, it's a question that I can't really answer. We have not, this regulation, as you see in my slide, is that what was I going to say? It's being litigated right now. So we don't have very many cases that have really gone through yet. So the order itself is being challenged by San Jose, New York City, the city of Eugene, as you can see on the slide, to say, we don't believe you, FCC, have the authority to interpret the law in this way. So we are going to challenge you and say, you don't have the authority to restrict our fees in this definitive manner. The Telecommunications Act does not limit the fees in this way. It says we are entitled to fair and reasonable compensation. You don't get to define that for us. The FCC is saying, yes, we do, and now we have litigation. But because of that, because we're in this litigious atmosphere, or in this maybe not litigious atmosphere, but because we are still within that context, I don't think we've had any cases that have come out. I've not seen any cases. They are generally going to be federal cases because this involves the FCC, because this involves the Federal Telecommunications Act. We don't have any state action on this yet. So I don't really have an answer for that question because we're just not there yet. I would say it's best to be prepared. Adopt a fee schedule, adopt an aesthetic policy, and then be ready to enforce it. Okay, let's see. If a village adopts regulations requiring planning board approval, will it require the county planning board, assuming that it falls within one of those 500-foot trigger areas, and seeker reviews. So that's a good question. I don't have a great answer for that. Planning and zoning is not my area of expertise in particular, and you might say that doesn't make any sense. We actually try to separate our issue areas at NICOM, but Wade Beltramo, as I'm sure many of you are familiar with, would be happy to help. If I were to speculate a little bit, to me, there's likely going to be some engagement there. All of this will, in a lot of ways, will invoke some type of seeker review. Okay, if a highway or other permit is county or state, not local, does this impact the shot clock? That's a good question. The state is also required to adhere, so all local governments, all local siting authorities are going to have to be involved with this. So if we happen to have an installation that is in a village, for instance, but on a state road, it's really going to be the applicant's responsibility to notify the state, and you just need to make sure that you are doing everything you need to do within the shot clock, and then the applicant will have to see what other types of approvals that they'll need to obtain. But it's likely going to all fall within that shot clock, but you as a local government need to make sure that you are adhering to the shot clock. Because remember, the remedy to that is that the applicant can go to court and say, please grant me approval. They haven't responded within the appropriate period of time. I've given them all of my documents, that type of thing. Okay. Can small cells be placed on fire halls in New York, or are the restrictions in California court decision removing? So I'm not familiar with small cells being removed from fire halls. There's no similar requirement in New York State. And then there's a question about, what about the community of Oyster Bay that has denied the placement of small cells? There are lots of communities that have, and I think most of them are experiencing litigation. So again, none of the cases have really been decided that I'm aware of, or not decided on the merits necessarily. So I'm not sure what's going to happen with ripping apart, telecommunications policies and that sort of thing. Okay. And a lot of these questions I want to address are really to anticipate 5G development. Remember, it's not necessarily going to be 5G, right? So it could be 4G development. It's about network densification, not just 5G. So just keep in mind that your policy should be updated, but it's going to be for both 4G and 5G. So of the municipalities that have proactively updated their code in anticipation of 5G development, have most gone with the greatest allowable fees, or do they do a lesser fee as an incentive? So I think that's up to the municipality itself, right? So many do the presumption. There are still others that have decided to exceed the presumption. The city of Rochester. The city of Rochester is also being sued. So it's a little bit of a risk analysis, right, of whether or not we want to have lesser fees to, again, make ourselves more attractive. And I think that's a great way. I think in order to show an applicant, because there was one question from before, who makes the application? When does this process get started? And it gets started by the industry making a business choice, really, to come to a particular location. So if you are an attractive location, right, you are ready to go. You have your policy in place, you have a reasonable fee schedule, and you're just waiting and willing to have that technology, then I think that would definitely help the industry make a decision to go to your community as opposed to the community down the street who doesn't have those things in place. So certainly, municipalities have chosen to have lesser fees. That's completely authorized under the regulations as a way to incentivize the deployment of this technology. So the process for obtaining higher fees would just be to adopt higher fees, excuse me, but you would want to document the reasons why you were using those higher fees. Okay, let's see. Who has jurisdiction over the poles within a highway right of way? So I think what you, when this person is asking about a highway, they're likely talking about a state highway. And I think there needs to be some coordination between the local government and the state. This is something that we're going to be looking at and haven't, so I apologize. We haven't followed up with that one, but that's a good reminder for me to think about how is the state working with local governments when reviewing these types of applications. Okay, let's see. If the town wants to erect its own tower on town land and then rent the space, can the tower give preference in terms of a special preference to itself in terms of a special use permit? So I think what you're saying is if you want to put a tower in a place that's not really zoned for it, can you allow yourself to do it? Again, unfortunately, zoning is not my particular area of expertise. I think that would probably not be allowed, but I'm speculating a little bit there. You still need to be you don't have, I don't know of any preferential treatment a local government can give itself in zoning. But so that's sort of where I am under your Article 7 or your version of Article 7. So I don't know. That's a good question, but maybe shoot me an email and we can have that conversation after. So we have a few minutes left, and I think we'll have enough time to talk about my remaining slides. So I mentioned that we have this action. We have many cities across the United States, after the order came out, filed litigation to sue the FCC, as I mentioned, stating that they did not believe the FCC had the authority to impose this type of regulation on local governments, right? So because there were so many of these actions filed in federal court, there is what I understand to be this consolidated lottery system. So the cases were all put together and given to the 10th Circuit. The 10th Circuit denied the motion to stay the order, so denied the motion to suspend the order while the case was pending. And then there was a transfer granted to the local governments, transferring the case to the 9th Circuit, which is important because the 9th Circuit has had more favorable rulings in the past relative to the local government. So if I have sounded anti-industry during this presentation, it's probably because I am coming at this from a perspective of, again, this sort of strong arming against our members, right? And I don't like that. And I want to make sure that internet connectivity is brought to all of New York State, but is not done in a way that defeats the intent of the local government, and the local government can ensure its safety and aesthetic considerations. And really, they're the ones that are, driving this train as opposed to the industry itself. So certainly the 9th Circuit in the more favorable court, so that's great for us. Oral arguments were heard on this case back in February, and a ruling is expected later this year. I don't know how the virus is going to be impacting that, if at all, but hopefully we will have some type of decision. I'm sure it will be appealed, so we are still years away from any real definitive guidance on whether or not we will be continuing to operate under these regulations. we talked about fees a little bit in the question and answers, that I usually recommend that the local government adopt a separate fee schedule outside of its telecommunications policy, so that you are more easily, it's more, oh goodness, you are able to change it more easily should, let's say, this litigation be successful and the order be thrown out. So you can increase or decrease your fees a little bit more effectively if you have it as a separate separate policy or separate schedule outside of your policy. Okay. There are also 3 bills that I'm aware of in Congress to both codify the regulations and to eliminate the regulations. So depending on which side of this spectrum you are falling on today, you may be supportive of any number of these bills. So there's the Streamlined Deployment Act by Senator Thune. It would basically codify all of the regulations that have just been, that were adopted by the FCC, right? So it would really put in place. And the issue with that is it's a lot harder to change a statute. But if you are in favor of this regulation, you'd be very supportive of this, right? So that's just the danger of statutory action. So now we have 2 very analogous pieces of legislation also before Congress. So one is in the Senate, and it basically eliminates everything the FCC has tried to do relative to this issue. And it's really, and I would agree that it's about restoring local control over these decisions. And then another one in the House to, again, basically just eliminate the FCC ruling. So in New York State, we've had 2 major attempts to have state action to, in a way, codify what the FCC has done. To me, and my perspective, out of concern for our members' autonomy and authority, we are not a proponent of any type of state action. Whether or not the FCC has the ability to impose those regulations will be answered through the litigation. The states most certainly could adopt regulations that would preempt, or not regulations, they could regulations as well, but they most certainly could adopt legislation that would preempt local decision-making relative to the installation of these structures. So back in 2018, there was a proposal in the governor's budget, in a way codifying a lot of these types of limitations on siting review, limitations on fees, limitations on what you can, not just fees, but how long you have to take and your aesthetics. I think I said all of them, but or maybe I said them more than once. But the governor had in 2018 that proposal. Again, it was contained in Part BB of the TED budget bill this year, but it was not adopted as part of the enacted state budget. Even with the virus sort of derailing or changing the state budget process this year, it seemed as though the legislature was not going to be in favor of this type of preemption. So we were happy about that. It would have imposed a lot of limits on insurance and indemnification that you as a municipality could impose on that applicant. And I thought that was, we collectively, NICOM thought that wouldn't be good for local government. When I say that the industry will not stop their effort, this is a very industry-driven type of proposal. Based on the language of the proposal, it was evident to me that it wasn't drafted by a member of the governor's staff, because it was really talking about zoning in the right of way, which, as you all know, we don't have in New York State. So I think it's something that we need to be mindful of. And if you are interested in supporting basically local control, then to me, you would be supportive of eliminating legislation like this. I have heard that the pandemic has in some ways highlighted, both in great ways, admirable ways, and perhaps manipulative ways, the need for universal coverage and how important access is for all of us during this time. And so the industry, I think, is saying, hey, we still need to have our applications reviewed because we really need to get this network deployed. And I think that's perfectly legitimate. I think, again, where is the network being deployed in the equity arguments that are there? I think are important as well. So a question that you might be thinking, well, what about the shot clock during this time, during the pandemic? What can I do? The FCC's order does not specifically talk about local governments and reviewing the application or tolling or pausing or putting a moratoria on a local siting authority's review, but it does contemplate a state needing to adopt an emergency moratoria to protect public safety and welfare. And I think a similar standard would apply to a local government. So I would absolutely encourage you to talk to your municipal attorney and speak with your applicant. And I would hope that together there would be a solution that you could achieve with your applicant if any of you have pending applications right now. So my recommended practices are to adopt your fee schedule, adopt your aesthetic policy as soon as you can. Get something in place. You can always modify it as time moves on, as we get more information. But as long as you have something in place, you have a great foundation to address these applications when they come to you or now that you have them. So usually I recommend that you evaluate all the costs associated with your right-of-way maintenance. I know that the city of Rochester was really able to value that and put an actual number on that. Some smaller communities may not have the ability to actually put a number, to actually determine what the cost is. So it might be better to rely on those presumptively reasonable fees, but that's going to be a determination you make as a local government. Okay, so again, it was April 15th of last year. I'm not concerned about that date. I'm confident that you can, as long as you haven't, the issue will become if you have an application and you didn't have a policy, would a provider say, you didn't have a policy last year, but now you have one this year. So Verizon, when they applied last year, got a better deal. I'm not sure. I don't know if we have any evidence of that just yet, but I would say try and see what happens. Because I think it's important to try to have something published in advance that you can apply uniformly. So all those design standards, remember to consider. Remember that moratoria in sort of normal times, or the before times, as my husband likes to say, are maybe okay currently, but not overall. So tolling is okay. Maybe there may be opportunities to have moratoria today, but it certainly must be very, very limited, and don't just rely on the conditions in order to suspend reviewing an application. Okay. As with anything in local government, document and support your decision making, and make sure you have adopted a policy before you try enforcing it. Okay. So just to point out, these are two examples that I have included on the bit.ly link, the short link. That these are the two of the policies that I have included. Include the town of Bedford and the city of Rochester. Bedford requires a permit, insurance indemnity I absolutely would encourage you all to consider those types of requirements in your telecommunication policy, and they have a separate fee schedule, as I've mentioned many times, as I think is really important. I also think it's important to document where these things are going. So where are these attachments being installed within your jurisdiction? And I think creating a record of that as the applications come in is really important and is a good best practice. City of Rochester rejected the shot clock, rejected the presumptions, getting sued. It'd be interesting to see how that transpires. I believe it is in state court, so I'm not quite sure how that case is going to play out given the federal case that is also going on. So let's see. That is the end of my slides. Those are the links again. And I'm happy to do some more questions, Katie.
Yep, I wanted to throw a few things out. People are starting to log off, but we can stay on to answer some questions. We did check those bit.ly links, Rebecca, and they weren't working for us earlier, so we'll just have to double check those for people.
Okay.
But we'll make sure that's working pretty soon. We have everyone's email address that signed up for the webinar, so we're going to proactively send out to everyone the slide deck, a link to the video, and update it, and just making sure that these links work. We also during the webinar found out that AICP CM credits are going to be available. So that's good news for any of you that need AICP credits. And lastly, we do have a certificate of attendance that we've developed, and we will send that out on the email as well. So just that's some general information, and then Rebecca, back to you for any more questions you want to answer.
Sure. It wouldn't be a small cell presentation if some technology component didn't work well, right? I always seem to have one thing happen or another with technology with my small cell presentation. So I will check the links. They may not have been made public. They're there, but they might not be, like I said, active. Okay, let's see what the questions are. Let's see. If you don't have zoning, can you still adopt the law for 5G? I don't see why not, because to me, you are adopting a small cell policy that is affecting your right of way, and your right of way doesn't have zoning anyway, so I don't see any issues with that. Let's see. Do you have any examples of New York State municipalities that have had applications, that have approved applications? I don't. That's a good question, but I don't. I know that in the upstate part, when I say upstate, I mean like all of us, but of north of basically the city and Long Island, have had a different experience, or are experiencing a different approach with Verizon and AT&T when it comes to applications. And I know that in the Hudson Valley, in the Southern Tier, and out west, there are devoted Verizon teams that are meeting with municipalities to talk about network densification and network creation. So, and they have seemed to be very productive. I don't know how far along, even when the conversation has started about these areas, if there actually have been any applications that have gone forward and been approved. But I know all over Long Island, they're denying them, and it's something down there for sure. Okay. Okay, let's see. I think, Katie, we might have, let's see. I spelled devices wrong on something, so I'll have to correct that. And has NICOM prepared model regulations? I have not prepared our own version of a sample policy. It proved to be quite the undertaking, so I have graciously accepted samples from our members and from town attorneys that have shared their versions with me. So I have a variety of samples available eventually on my short link. And my recommendation is that a local government review several of them. You're going to see a lot of similar themes when you, like, the sections will all kind of be the same as all kind of, I think, local laws like this have, right? They all kind of get reused after a while. But you look at which ways you can, as we do with all local, or should be doing with local laws anyway, modify that policy in order to really address the needs that are present in your community. So there are lots of them. Some of them, I will say, and please read my please read document. I again explain that these are not prepared by me or the NICOM staff, and some of them may not adhere to some of the shot clock or fee presumptions. So be careful that you're not just taking a policy and saying this is going to work. You need to be mindful of the regulations that are in place now when you are reviewing them. Okay. Great.
Rebecca, do you want to give a plug for your funding presentation tomorrow? I see someone asked about that in the questions.
Oh, thank you. Yes, we were talking about that. Securing federal funding in a time of crisis. Brought to you by your neighborhood NICOM Executive Director, Peter Bain. So that is tomorrow at 10 a.m. And registration is free and available to, I think, anyone who wants to log in. I'm looking at it on my phone, and you register. It's limited to the first 500 registrants, but I think it'll be really exciting and engaging. And it's also featuring Irma Esperanza-Diggs, who is the Senior Executive and Director of Federal Advocacy at the National League of Cities, which NICOM, we are a member of NLC, and I really rely on them for our federal advocacy. So really, thank you, Katie, and that's great. Okay. Yeah, so there's a question here. How are towns expected to be prepared to rule on the completeness and compliance of regulations? This is very technical, and you need to hire a third party, and they're not, you can't, and they're not, I'm going to understand that question to be you can't be compensated for that. I know it's a very, for me, it's a very frustrating component of this, that we do have so many small communities that don't have the manpower to have, or have to have the expertise in this particular area to really do this. So you need to rely on a field expert, but your fees are going to be limited. I would suggest, if you can work with your applicant to explain that, or to try to work with them, maybe they'll allow you to put some of the costs back on them. It might sound funny, especially coming from an attorney, to say, like, try it out, but as long as you're working with your applicant, it seems as though the providers have been much more willing to engage and assist the community in moving this along, when the community is demonstrating that they want the technology, that they want to approve the application. So I would say really try to work with them to try to get this field expert. And then we have, I think, one last question. When 5G comes on the scene, will the providers have authority to reduce 4G service? No, not really, right? So just like we have 3G is still active out there. My husband, I use this example all the time, that my husband is from Plattsburgh, and when we drive through the Antarctic Park, we lose service, and I am like, well, hopefully my husband's driving with me this time, because I won't be able to get in touch with AAA, and I don't know how to change a tire if I were to have an issue. So I I don't believe, but in other parts of where he grew up, my 3G will still pop up on my phone, right? So I don't believe that. I'm confident that 4G is not going away for a long time. Our phones don't support 4G and 5G right now, or many of our phones do not support. Certainly iPhones do not. So that will be that's not going to go away for a long time. It's still going to be there and available. And I think that's about all the questions.
Great job, Rebecca. Thank you so much. And thank you for staying on past the noon time frame to answer some of those questions. We'll do our best to have this video and everything posted tomorrow, but bear with us if we don't get it till early next week. And again, thank you very much for attending and have a great day.
Thank you. Thanks, everyone.
Bye-bye.